So let's wait that presentation appears. Questo mi conforta molto, quindi già pochi ma buoni. So the presentation is here, but Marius is also here. Okay. Yeah, please. So I open this last session as far as papers presentation is concerned. Welcome to everybody. We are lucky and also delighted to have all our speakers in presence, which is an exception, I think. So all the three papers will be presented by colleagues who are here. And we agreed upon a 20 minutes presentation each, followed by, I think, directly by questions from the audience and then some remarks from my side in order to close in time to start the commemoration of Marco Biagi. Our first speaker, Marius Olivier, both from South Africa and Australia. So this, the floor is yours about social security for platform workers in the wake of the pandemic.
Thank you, Edoardo and colleagues, and thank you also to the organizers. It's certainly been a privilege over the years to attend, even though we couldn't do so during COVID-19. This is an area, of course, that is increasingly attracting attention, not just in the European Union, but as you will see from many quarters in the world. And I think COVID-19 has accelerated the pace at which this is being looked at, but also the nature of the solutions being sought. What I want to look at briefly is to a few introductory remarks, among others the concept of platform workers, look at the impediments in social security or social protection terms experienced by these workers, some comparative reflections as we see them happening all over the world, some really interesting modalities being applied outside there. If there's time, we'll say a few words about key principles that should inform further or future coverage of platform workers in social security, in the social security sense of the word, and their access also to social security. And then to look at only one issue around the how to achieve social security coverage extension and access. And I want to focus on one issue which I personally believe to be critical to the the further debate and even to any other kinds of solutions in other areas in relation to social security for platform workers. Had we had time, then we could have dealt with other fascinating areas such as issues of representativity. We could have delved into collective bargaining, but there's no time for that. And then a few conclusions. Right. Now, mindful of the time, I will may have to skip some of the issues. There is no one single agreed definition of platform work. I think, roughly speaking, we all know what we're talking about. At times it's being equated with gig work. At times it's being seen as larger or narrower than gig work. The OECD, however, defines this as, there's a focus on individuals who use an app or a website to match themselves with customers in order to provide a service in return for money. I am deliberately this afternoon also referring to and quoting from some developing country perspectives, because I think not only is this a universal issue, universal problem, but it is fascinating actually to see what some developing countries are doing to deal with this matter. And India published fairly recently a code on social security, and their definition is as follows of this phenomenon: a work arrangement outside of traditional employer-employee relationship in which organizations or individuals use an online platform to, now listen to the variety here, to access other organizations or individuals to solve specific problems or to provide specific services or any such other activities which may be notified by the central government in exchange for payment, unquote, deliberately extensive. And if you were to appreciate the structure and the framework of this particular code, what it does is to provide a number of definitions extensively. And then it says, well, now we know whom we are talking about. Now here is the framework for the extension of social protection. And this is clearly a legislative attempt, without going into detail as to how they do it, to cast the social protection, in particular social security net in India, as far and as wide as possible. Of course, it still has to be concretized, and we're not going to talk about that this afternoon. So worldwide, if I could try and summarize still by way of introduction, the social security position of platform workers differs quite dramatically for the moment. There has been a deliberate attempt, and still today mostly so, and we want to interrogate that attempt, to equate the social security, or link the social security status of platform workers to the labor law status. So much depends on what is happening in the labor law debate as regards the widening of employer-employee concept, or just the employee concept perhaps. At times, the legislation and jurisprudence also tries to deem platform workers to be employees in order to extend at least the contributory context then of social security to them. But on the other hand, we have seen some other responses in other countries, even from a labor law system perspective. We want to argue that perhaps there's a different way of doing this. So what then are the impediments, legally so at least, but also otherwise suffered by platform workers? There are essentially 6 issues which I would like to highlight. The first is, of course, as we find even in labor law, misclassification, very often deliberately so, even to the extent of concealment of the true nature of relationship with the platform in order to avoid social security contributions, for example, but even more disturbingly, to try and rely only on, if it does exist, the so-called main job of the platform worker concerned. And as you can see, this brings about quite a bit of distortion. We don't have time to read that particular quotation. So we have to be very careful in how we deal with this, also in searching for solutions. Secondly, the traditional view, of course, is that only employees qualify for the, and I want to underline, the full spectrum of social security coverage arrangements. And that maybe is why we partly have this attempt to try and extend the employee notions to cover them as well, at least in some countries. And I must say it's a problem even in some of the welfarist systems, legal and other systems, even Australia, one of the countries I'm involved in, even there, an employment relationship may nevertheless be required for certain social security purposes, one of which is workers' compensation. In the third instance, there have been recent attempts to extend coverage to also include self-employed workers. Quite a good bit of work has been done in this regard. I refer to instruments that are quite well known in this part of the world, the EU Council recommendation on access to social protection for workers and the self-employed, addressing this issue, and then also Principle 12 of the European Pillar of Social Rights, which seems to open the way for, going beyond just, generally speaking, the employment relationship. But nevertheless, if one wants to apply this in the country-specific context, whether in Europe or outside Europe, then one would have to make sure that there is a specific legislative instrument to do this. And the other problem is if we were merely going to capture the so-called self-employed, I'm afraid we may still miss out quite a number of platform workers who do not fit either the definition or the scope of employee, traditional understood, or even self-employed. And I think the supply chain scenario is one of many scenarios where we see this difficult hybrid forms of employment that actually we do need to cover. I do suggest to you, and I'm not going to discuss this, that the official ILO instruments are of very, very limited assistance, including the well-known employment relationship recommendation of 1998. That doesn't bring us further, in my view, as to where we want to be. Related challenge in the fifth instance is the cross-border and the global nature of platform activity. Many of our platforms operate as multinationals with a web of complex work and control arrangements. So here we have to make sure that at least there is some way to extraterritorially apply the regulatory framework that is being developed in a particular country to make sure that, platform workers are covered. And think of the many Uber cases we have had around the world where in some jurisdictions, of course, they say, sorry, we can't intervene, it's outside our jurisdiction. Very nice quotation, which unfortunately I don't have time to read, from Christina Behrendt and her colleagues, and quite a formidable ILO publication of 2019 on the issue. And then finally, the fluidity and multi-job nature of the arrangements that we see. People may kind of oscillate, they may move between platform work and other forms of work, and we don't have this transferability or even portability. So you can see the complex web of issues. Right, the comparative experiences, and I'm going to highlight a few of them. The first is what we experience quite a bit of currently, and very often a very forced approach, with due respect, to accord employee status to the platform workers and to deem the platform as the employer. Yes, you can do this, but in my view, I think only to some extent. This would then imply the accrual of social security rights. But then we have several very interesting alternative approaches. This guy Davidoff with his purposive approach, which I think most of us actually know. He says, well, what is the purpose behind what you want to achieve through the legal framework? And you make your arrangements accordingly. There's an alternative approach involving independent employee, dependent contractor approaches, and other hybrid approaches. But then, quite fascinatingly, and I want to spend a minute or two on this, is what I would call adaptive social protection approaches. And if you really analyze what's happening in the world, these approaches we find particularly being reflected in both the developed but increasingly in the developing world, where there's an attempt to undertake social security reform. And the kind of reforms that we see, and I want to stress even, and in particular nowadays in many, many countries in the developing world, is firstly an expanding contributory social security framework to cover vulnerable and excluded workers. Had we had time, I would have discussed with you what our developing countries in Africa, Latin America, and in Asia have been doing the last 10, 15, 20 years to expand or extend social protection, contributory social security in particular, to those working in the informal economy. Secondly, the increasing introduction of universal schemes, even in the developing world, pensions, health, maternity, and thirdly, even extending non-contributory tax finance schemes on a universal or categorical basis, and linked to quite a few interesting issues. The one is sometimes a subsidy on the part of the state, but also to a decisively calibrated combination of contributory and non-contributory arrangements. All fascinating, but no time for us to discuss this. We have to ask ourselves, what does this mean for platform workers? The fourth comparative experience, to streamline contributions and innovative funding solutions. I'm going to give you two examples. The one is closer to home here. The German Artist Social Insurance Scheme, which relies, or uses rather, non-individualized global or total contributions, if you like, on the total contract value payable by the contracting employer, complemented by workers' contributions if earnings exceed a certain level, and then supplemented by government subsidy. Very, very interesting approach. And I now want to tell you, colleagues, that what I've just discussed with you, exactly what we are seeing in countries such as Ghana, Rwanda, several Southeast Asian countries. These are very interesting, novel experiences. Latin American countries, they toy with different possibilities. The one is the monotax system, where tax payments and social security contributions are paid as a single package, also as far as so-called independent workers are concerned. In the EU, finally in this regard, 2020 letter of intent, initiative to improve the working conditions of people working in the platform economy. That led at the end of last year to the publication of the European Commission's proposal for an EU directive on digital platform workers. And what it does is to use the deemed or presumed employment relationship as a basis for determining access to social protection rights, which, in my view, would still leave other platform workers outside the proposal scope of coverage and social protection guaranteed in the proposal. We don't have time, but there is a kind of a summary of what the proposal for the directive actually is doing. Right. Comparative reflections on current coverage and access modalities. Still on this, finally, an interesting draft report by the European Parliament of 2019. And that report deliberately tries to suggest, you know, we really have to look beyond this attempt to put everything under an employment concept, employee-employer concept. We have to look at something which is not dependent on employment status. Right. Key principles and values. An audience such as this, in particular the lawyers amongst us, there's certainly no need for me to try and convince you of what our international norms and standards actually suggest, that we really don't have a choice. Social security is there, or social protection is there to be extended literally to everyone, including every person who works. Right. The principles and values that we might have to bear in mind, well, no time to discuss this. I want to come to the critical issue then, which flows from all of this before we conclude. And in my view, I think we should pay more serious attention to the need for delinking employment status from the coverage that platform workers should experience in terms of social protection access and coverage. In other words, coverage despite the absence of an employment relationship. Perhaps a new worker classification, some would say. Harris and Kruger referred to this as independent workers, so to say. Fredman and Detroit would say it's time to consider ways of transcending this binary divide and ensuring decent work in the labor market irrespective of employment status. It rings a bell if you look at the ILO's decent work agenda as well. Secondly, special regulatory frameworks for specific worker categories. Also there we see this movement beyond just, you know, employee notion traditionally seen, teleworkers, and then also, interestingly, operation of EU anti-discrimination law as far as so-called part-time workers are concerned of employees. So still employees though, but at least it gives us an idea to a different approach, a regulatory approach. Contextual perspectives, importantly, the expansion of the boundaries of labor law and of labor law to non-standard workers and the social security implications. But, in my view, and I don't think it's just my view, that's why I heard many other lawyers are saying that the extension may only or primarily benefit so-called employee-like workers. There are boundaries to how far we can get, what we can achieve by extending the scope. And the value for independent workers, the self-employed, and several other non-standard worker categories, therefore, that remains questionable. The report by Alain Supio, quite a number of years already ago, to the EU. Now, we all know the report and the content, but eventually he is actually saying, once he has discussed these various concentric circles of labor and social protection, very interesting depiction by him on that. But then he said, the second last bullet, in fact, he said, it is not necessary to move beyond employment. All forms of work are worthy of protection, not only subordinate work. And I really would like to think it gives us a lot of room for thought. And again, I refer to the ILO's decent work agenda. We see interesting related experiences, if I could use the word, in OHS, Occupational Health and Safety, where, as you all know, the coverage of OHS is no longer restricted to workers, traditionally understood. In fact, even people who do not work are being covered, but even all categories of people who work. And they don't have to work at the workplace of the employer. They can work anywhere, so to say, and they will be covered. And we have seen this deliberate extension of the scope of coverage of OHS legislation over the last 20 years, in particular, Europe included. Finally, other regulatory techniques, supply chain scenarios, fascinating developments we see in a number of countries, and I think Australia is probably a very good example. The statutory application or extension or adjustment of a statutory floor of minimum conditions of employment with their social security implications. The deeming provisions, but also rights of recovery. In essence, what it says that if you are a supply chain worker, because of these deeming provisions and the legislative net of protections out there, you are able to recover, to claim, literally from anyone in the whole chain of command, whether you even know them or don't know them. If, of course, you have to establish the chain and who are in the chain. And then mandatory codes that place certain obligations on the providers of work. Finally, conclusions. I'm suggesting to you that also a result of COVID-19, but as emphasized by the ILO Global Commission for the Future of Work, the greater exposure of workers to social risks increases the demand for comprehensive and adequate social protection and access to healthcare throughout people's lives and facilitates life and work transitions, which is a general social security principle in any event. It's clear that no one size fits all. We have seen different approaches. But COVID-19 has stressed the need, in my view, to think innovatively about modalities and techniques to achieve coverage extension to enhance access by platform workers to social security. There is, in my view, as I've tried to indicate to you, need to seriously consider delinking coverage by and access to social security for platform workers from employment status as we traditionally understand that to be. And that COVID-19 has revealed how detrimental reliance on the existence of an employment relationship could be for, how detrimental that could be for the precarious position in which platform workers find themselves, especially those who are not or could not, by any figment of the imagination, fit the definition of employees. I thank you.
Thank you very much, Marius, for this very thoughtful reflection on social protection at large and social security of platform workers, and more in general the inadequacy of the employee self-employed distinction to fit the purpose of social protection and as a classification tool. So our second speaker is ready, Claire Manzo. We are still we'll be still talking about social protection. We have a quite different angle, and I'm very happy to have two papers that approach the same subjects in a different way, so we can also compare the different approaches. Please, the floor is yours.
Thank you very much. Just to make sure I understand. Yeah,
okay, yeah,
that's fine.
It's
thank you very much. I'm very happy to be here, and I know it's late for everybody, but I'm glad to see that there are a few more people than when we started. I would like to thank the organizers. I would like to thank Edoardo, and I would like to thank the first speaker, because to be completely honest, I'm going to tell you the exact same story as him. So I might as well not say it, but actually you'll see that there is a point. And in fact, I'm kind of making a link with something else we heard today, which had to do with the distinction between public and private help. So pretty much, as I've said, I'm going to make the same point, but I'll make it in a different way, and hopefully it won't be too boring. So first of all, I'd like to say that this is part of the CEPASOC project, which is a project which is going on for 3 years, which was funded by the ANR, the French National Agency, Research Agency, and it aims at focusing on platform workers' social protection. I won't spend too much time on this, but I just want to go to the point. So let me start now. And I'll start by saying that even if social protection is quite broad, actually, and focuses on many different subjects, I will only look at access to healthcare as well as access to minimum wage in this study. Second thing, I'll focus on platform worker statuses, and it has already been explained, but I just want to make it clear for everybody, although I'm guessing that most of you already know that. When we're looking at platform work, not only are we looking at many types of jobs, we can be talking about micro work, deliveries, or cleaning, but we're also talking about many different statuses. And in fact, the previous speaker just explained to you that mostly we were distinguishing between independent workers and employees. In fact, in some countries, but not all of them, we'll add a third category, which is the category of workers. So that can be in the UK, but like in Italy, actually, and in Spain, we have these third statuses. The point is that platform workers, even if it is one category of work, can be treated in different ways. And so we're going to look at that more specifically when we're looking at the strategies which have been put in place in order to fight COVID-19. The last thing I need to say in this introduction is that I'll be looking at 2 types of insurances. So we're talking about platform workers, we're talking about public and private actors' strategies to deal with these platform workers' needs. We're talking about their social protection. And in order to look at this social protection and how they can get help and protection, we need to look at insurances. And so that's why we'll look at public insurance. And in fact, you know that public insurance is one of the foundations of social protection, but we'll also look at private insurance. And I felt that it was interesting to add this because, as you'll see, in some cases, public insurance is not enough. And so we've had to look a bit further. So what I'm going to do today is to focus on the reality first. So in the first part, we'll look at what actually happened in France and in the UK. And having looked at that, we'll turn to hypothetical evolutions. We'll try to reflect on the changes which have taken place. I know it's late, I'm not going to exhaust you, so I'll be quite quick on the first part. And if you want to know more about it, please have a look at my paper. And I'll spend a bit more time on the reflections it led me to. So here we go. First of all, platform workers' social protections, legal practical changes to face the pandemic in France and in the UK. So the first thing I want to look at is the public actions, and here we go. So what happened when the pandemic started? First of all, everything closed down, and it was incredibly fast, and we were quite surprised. And rather quickly, actually, the British a bit less quickly than the French, and you might remember the declarations of Boris Johnson at the time, started to decide that there was a need to help the workers. Which is why solidarity funds were created in a French law on the 24th of March 2020, which created what we call the activité partielle, which is, a furlough scheme. And in the UK, kind of the same idea, what we called a UK job retention scheme, which aimed at helping the firms help the workers. And I'm guessing you all know what we're talking about here. The point was that the state was sponsoring the firms to help them pay the workers even when they couldn't do their job anymore. The issue was that the very model and the inherent, the philosophy which was behind this scheme meant that you needed an employee, since it was the employee who was going to decide who would get the money. And obviously, it didn't include self-employed people, which is why, rather quickly, but a little bit like a few months later, they had to create another scheme in order to include independent workers and to give them access to some sort of solidarity fund. It was done in France, it was done in the UK, with something which was called the Self-Employed Income Support Scheme. I won't go too much into details, but I just want to say one thing. It was hard to meet eligibility criteria. And in fact, because there were very specific criteria on which I won't spend too much time, it was difficult for some workers. It was particularly difficult for vulnerable workers, and it was particularly difficult for self-employed workers. The problem was that it did not take into account the fluctuations in turnover, meaning that if you had changed jobs, that made it pretty much impossible to access the scheme. It didn't take into account the length of service in activity. So in fact, usually there would be a criterion which would say you need to have been in that job for like 3 years initially, then it was changed. And if you hadn't earned enough, and in other words, you hadn't lost enough by comparison to what you were earning before, you didn't get access to the scheme. In other words, you had nothing, you get nothing, which means that some people were in a difficult situation. I won't spend too much time on this, but I just want to say that it evolved a little bit with the second wave of COVID, but still there were inequalities, to the extent that the Independent Workers' Union of Great Britain, which is a trade union, started a case, which did not lead to anything, but which shows that there was a worry about that. So this was one action. The other one, obviously, when it comes to social protection, is the classic social protection. And we need to have a look at that in order to assess the help which could be given to platform workers. I'll go quite quickly, and so I'll just very briefly say that there were compensation minimum wages which were raised and which were extended. I won't say more than that. When it came to sick pay, no changes, and in fact, mostly it is not very available to self-employed workers and to independent workers. When it comes to access to healthcare, again, no changes, but again, we need to know that employees are in a better position. What's interesting is to see that beyond these state changes which were studied, and because it was noticed that there were lacks, the platforms themselves, not all of them, but some of them, and in this case I only studied Uber and Deliveroo in France and in the UK, decided to react. And they decided to propose an emergency response in face of COVID-19. So there were very practical stuff, such as contact-free pickup and delivery, provide face masks and hand sanitizer, or provide free internet doctor appointments. The more interesting one is the fact that sometimes there was a financial assistance. And so I've copied and pasted what was written on the website, and you have the link here as well. You see that Uber will provide, so it doesn't exist anymore if you look for it on the website, it did, it provides the drivers with £100 per week for up to 14 days. But there are conditions. Documentation from a licensed medical provider, an order by a licensed medical provider to requiring the driver to self-isolate, or a NHS 111 self-serve certification, which is some sort of certificate that you can get. It's a bit unfortunate because we can't see it here, but the point is to see what I had put in red, that if you are eligible for assistance, Uber will temporarily restrict your account access. So in other words, during the time you're receiving assistance. So in fact, it was a little bit difficult for drivers to ask for it because they would take the risk while their request was being assessed not to be able to work. And if they didn't get any money, obviously, they needed to work. So it's very practical, but we see how some sort of response was made and how it was made. If we go beyond that, we can see that Uber and Deliveroo also chose to propose insurances, and that's why I was talking about private insurances. Private insurances, in fact, asking AXA and BICMO to help the drivers. So in fact, it's free insurance, which is paid for by the platforms, which can be accessed by the workers. And here we need to make a distinction, but I've taken too much time on this, so I'll let you read it in the paper. The point is that not everybody gets an access to it. What I'm trying to say here is that this is not great. I'm sorry it's a bit fast, but you'll see hopefully the rest is more interesting, so that's why I want to go beyond. What's remarkable, though, is that we have some sort of ersatz form of social protection. And so we're questioning, again, the balance between public and private protection for platform workers. Which takes me to the second part, where I want to reflect on the hypothetical evolutions to face the pandemic in France and in the UK. What I'm trying to do here is to think of how social protection should evolve in order to take into account these needs. And first of all, and here I'm very much in line with what was just said. Sorry, this is not the right one. Here we are. I'm very much in line with what was just said, because I see a growing conscience of the need to protect platform workers. And in fact, you got a very beautiful demonstration just a few minutes ago. This recognition is made by the doctrine, as we just saw, but it's also made by private actors themselves when we see that the platforms are recognizing that there is a need to help the workers. We see that, in fact, even in order to promote work, to allow people to work, it's good to help them so that they can work. So there is like an economic rationale here behind. Still, because it's a recognition which is made by private actors, it might not be for the best reasons, and as a result, we could say that it is unreliable and definitely uncontrolled. There is a recognition by public actors. We see that the public protection is thought of. We have many reports which are appearing in many countries. It's the two countries I studied are France and in the UK. So in France, you might have heard of the Frouin report, which proposed the idea of a principle of neutrality, which is actually a principle which did not exist in French law, so it was commented. It did appear in the EU a bit and in the ILO. It's the idea that there should be some sort of universal social protection which is independent of the employment status. So we just talked about this. That's the general idea which comes from the EU and which appears in the social pillar, which appears in the action plan, and which appears in the ILO reports, and particularly from one of May 2021. It's also recognized by other actors. I've already mentioned doctrine. I should mention trade unions, and I should mention judges sometimes, which is quite interesting because in France we have this specificity of having a disagreement between some judges and the legislator. And that's quite surprising. Sorry, is it me? I don't know. Anyway, so it's quite surprising because obviously we don't know where we're going at all. And so at this stage, we just have no idea whether we're going towards some sort of presumption of employment, like the EU proposed, and as it was sort of made by the Cour de Cassation, or a presumption of independence, which is what was seen in the last law we have, and in fact, which was kind of implemented in a decree recently. Here we go. So, having said that, we can wonder about whether there is a fluctuating equilibrium between public and private protection. And I thought it was nice to go back a bit in history in order to think about that. And actually, when we look at the building of social protection, so either in a Bismarckian model, not everybody will agree to say that France is a Bismarckian model, but kind of, or in a Beveragian model, which is definitely what the UK is, since Beveridge was in the UK and proposed this report there, we see that already at that stage, and whatever the state input was, the social partners and the private parties, in other words, the enterprises at the point, the companies, participated. And we've always had some sort of, maybe not fight, but at least dialogue between, I still have 4 minutes, no, I'm at 16.
20?
Sorry, no?
2 or 3.
2 minutes, okay, I'll do more quickly. Sorry,
no,
I was counting,
right.
so I thought I was comfortable. Anyway, so just to say that there was a complementarity and an historic tension. So what would we say for today? Same old, in the sense that there is a threat of legislative action, and I've mentioned that, as well as a threat of judicial requalification. And so we still see this tension between public and private powers. Can we say that there is a new tendency as well, to a certain extent, because there is some sort of deresponsibilization of private actors, but I won't spend time on this. I'm happy to talk about it later if you want. So I'll just conclude in 1 minute in order to ask myself and you whether we can identify a new balance between public and private actors regarding platform workers' social protection in light of the pandemic. And the answer can actually be yes and no. If we propose a short-term analysis, the answer is yes. The pandemic showed gaps in public and basic protection. We just saw that. The pandemic showed gaps in private protection as well. And this led platforms to take more responsibility, but it doesn't oblige platforms to take more responsibility, which leaves us in a rather difficult situation. The answer is also no in a long-term analysis, because we've seen before this history of game of cat and mouse between public and private powers. We're still looking and hoping for a universal protection, and the responsibilization of private actors might or might not go somewhere. So obviously I finish with the question of the evolution, and as a lawyer, I feel a little bit limited when I say that it all comes down to a political choice. And I ask the question of what level of protection should be given to platform workers. Thank you very much.
So, thank you very much, Claire. I think that you introduce a very interesting topic, and that one of the relationship between the private and public actors, and I think this is something we should reflect upon by responding or trying to give an answer to the question of which social protection for platform workers, but in general to social protection of digital workers and workers in between employment and self-employment, if this binary divide is still of some utility. Without any further delay, because Barbara is already here, I will give the floor to Barbara Surdykowska and Sławomir Adamczyk from Solidarność. Are self-employed zombies more important than classic workers? So there's also kind of mystery in this question, and I hope you will clarify to the audience what it's all about. Please, go ahead.
Good afternoon. First of all, thank you for the Marco Biagi Foundation to invite us to this meeting, to this seminar. We are not a part of academia. We both, me and Sławomir, working as an advisor for Polish trade union Solidarność. So we are a little bit outside, let's say, more theoretical approach. And we would like you to speak a little bit about situation of self-employed person during the COVID-19 pandemic in Poland, and more concretely about the public support for this category of solo self-employed. And we know that we are a little bit provocative because the main discourse, which of course we can find in many publications after COVID-19 pandemic, is that there was a need, and we still see a need, to increase, to develop a kind of safety net for self-employed person, for solo self-employed person. And in our case, in the Polish case, we would like to show you that this support for solo self-employed person, in our opinion, was higher, was more developed than the support from the public money to the classic employee. So, first of all, I have to start with basic information that influence of the COVID pandemic on the Polish labor market was less severe than in the different member states. This is, of course, connected with general the Polish economy, which is less connected with some kind of the service, like, for instance, tourist activity. So that's natural that this situation was not so bad, like in the member state, for instance, in the South European country. And saying this, of course, there was a need to adopt some kind of the employment support finance from the public money, from the state budget. And what is characteristic, only I think, as far as I know, I can know only this one example of Poland, that the support was primarily focused on solo self-employed. And this support was connected mainly, there was some other forms, but two forms are most important: exemption from paying social security contribution, and payment of the special benefit, which before, of course, haven't been introduced, haven't existed in the Polish legislation. I called it standstill benefit. I know that maybe it's not a perfect translation, because this was a benefit which was for solo self-employed person, also for people on so-called civil contract, so the people who are performing work in economical sense, but they are outside the Polish labor code, Polish regulation. This is a contract for mandate, contract of service, and this standstill benefit was created because of this special pandemic situation. And the most important issue, I think, if you want to compare and to make some kind of argumentation to this, our TISA, that this support was firstly focused on solo self-employed person, is when you compare the amount of unemployment benefit and this special standstill benefit. And this standstill benefit was simply higher than unemployment benefit. So, of course, this can be, I think, very problematic, because this is showing that from the, let's say, even ideological point of view, there is something special about being self-employed, which we cannot say about being employee. There's one important information that Polish unemployment benefits are equal. So the same amount. It's not connect in any sense with your previous wage. It's not connect with the contribution which employer is paying or self-employed person is paying. So these amounts are the same, and they are relatively for a short period, normally for the 6 months, in some special circumstances for the 12 months. And when we look at the money which was spent on this standstill benefits, as you see, it's about 5 billion of Polish zloty, and he's showing me that I should be finishing this part. So this is quite a lot if you compare to other main social policy, like for instance this famous 500 plus for the kids, which is a most important social policy of our government right now. And the second, as I said, we have this benefit and also this exemption from paying social insurance contribution. So this person didn't pay their contribution, but in the future, this money will be a part of the calculation for their pension benefits. So it's not that they are losing anything, it just simply means that we will have to finance our social security fund in the future with the public money when there will be the moment when we exactly will be paying their pension. And look, I can't get rid of this small square, but I think this is really important, that the number of self-employed persons increased by 35,000 during the pandemic. So I think this is showing us something about I don't see this as a kind of a normal, from the economical point of view, situation when the number of self-employed persons is increasing during such situation as extraordinary COVID-19 pandemic. And now I will ask my colleague to present why we have so many self-employed persons in the Polish labor market.
Okay, I will continue. Why did they come on the Polish labor market? And in this part, we explain what we mean calling this person zombie. The Polish labor market is characterized by strong presence of self-employed, mostly solo self-employed. It is about 14.3%. This is one of the highest percentages in the EU. We are just after the Greece. So the problem is that many of those solo self-employed persons do not have any capital at their disposal to survive in the hard times, and in the event of an economic downturn like now, they only come back to business life after receiving a drip from the public funds. We call such persons zombies there. So where they did come? The first answer is go back to the history. At the beginning of socio-economical transformation, microactivity was often on the only escape route from the trap of unemployment. Let us remind that after 4 years of transformation in Poland, it was over 16% in unemployment, and it was still growing. Very liberal regulations favored taking up self-employment. But why do self-employed zombies still exist on the Polish labor market in a situation which is very favorite for normal employment? The situation is very excellent. The unemployment rate is getting lower and lower, just now about 3 or 4%, no more. First of all, it is driven by positive tax and contribution stimulation, which in the situation of generally low income in Poland is a temptation. Often with the support of the current employer, to switch to self-employment, in some cases it causes an increase in income by up to 1,000% compared to classic employment. So this is temptation. And at the same time, Poland do not have effective court mechanism to counteract that shift from employment contract to self-employment in situations of obvious economic dependence. And finally, the issue of image. The positive vision of entrepreneurship as an activity which is generally more creative than ordinary paid employment. It has been promoted practically since the beginning of socio-economic transformation. Could you imagine that for years in secondary schools have been teaching the following lecture: fundamentals of entrepreneurship, but not equipping students with the necessary knowledge on their future functioning of the labor market. And combination of these factors creates a large group of people who has neither the idea, nor the capital, nor the competence to run the business, but who are attracted by a strong narrative to be self-employed. Sometimes this leads to bizarre situation. This is an example from my city, Gdańsk, 12 years ago, after the collapse of the largest Polish shipyard. At its place, and another company has arisen, performing nearly the same activity and based on the work of over 1,000 solo self-employed former shipyard workers. So this is the reason. And a few remarks concerning the current situation, because the pandemic has not changed the approach of public authorities. No attempts were made to make any systemic changes that could restore the equilibrium on the labor market. With the prospect of a potential rise of unemployment, which happily did not happen, no attempts were even made to rethink the role of the special labor fund, which is created from employers' contributions for dealing with the situation on the labor market. But honestly speaking, this fund is now used by the government as some kind of piggy bank from which it can pursue money for any non-labor market objectives. So another issue, there has even been no attempts to reform the unemployment benefit system in order to increase workers' feelings security on the labor market. Probably you don't know, but we have very dysfunctional unemployment protection systems. It means that employee losing work may quickly fall into the poverty zone due to very low amount of unemployment benefit, which is not related in any way to his previous income, and the very short period in which he is entitled to this benefit. So there was not any trying to reform these systems. Instead, the self-employed were taken care of. As Barbara said, they received a standstill benefit at a level higher than unemployment benefit, and they were additionally exempted from paying social security contributions. But these contributions, those mentions, were recorded in their individual retirement accounts. And this means that in the future, the state would subsidize their pensions from the budget. Classic workers could only count on the fact that some of their social contributions would be covered from the public support which was received by their employers. So is this an equal treatment? I don't think so. Please, Barbara, your final conclusions, so, since you are a spiritus movens of this paper.
Okay, so So I asked him, is he alive? Yes. So we have another zombie in the room.
No more zombie.
No more zombie, okay. Okay, so, okay, to conclude. You can, of course, ask about the position of the Polish trade union. And the main position of the Polish trade union was at the beginning of the pandemic to increase the amount of the unemployment benefit, because it seems to be more natural and rational way in this special situation. And trade union haven't been able to achieve it. There was some increase in the unemployment benefits, but rather symbolical. There was some special benefit. It was called Solidarity benefit, but it was more connected with the presidential election, which we have in 2021, and it was a temporary measure. So as Sławomir said, COVID was, in our opinion, lost chance to rethink system as such, to rethink the role of the labor fund, to use it more for the training, use it more for the support of the employer, for the digital and greening transition. So we don't see any kind of deeper thinking about of the COVID to create effective mechanism to build more inclusive labor market. And I want to stress it because this is maybe strange, maybe I should start with this. Remember that in Poland, the solo self-employed person, when they are willing, they are able to pay the contribution, which allowed them, give them access to the unemployment benefit. So in the normal situation, when they are suspended their activity, they would get unemployment benefit. This is something, let's say, normal. There is a problematic situation, you suspend your activity, you get the benefit you are paying for. But the government, but this benefit is so low that, let's say, from the political point of view, it looks very bad, you know, that and very not friendly to the business activity. So because of this, they create the special benefits, which of course is not high from the, let's say, old member state perspective, but generally it's higher from the unemployment benefits. So from the political point of view, it was quite more easily to show this kind of this special care which is taken about after a self-employed person. To last sentence, so we still have a labor market full of zombies, in the sense that they are self-employed who are allowed not to pay social security if they wish, or they are allowed to pay very, very little social security if they wish. And if we have another crisis situation, we will have probably again to make some special benefit if the government will be still wanting to show they have special care about business activity, about entrepreneurship as such. So thank you very much for your attention. And of course, if you have some questions, we are open to answer. Thank you.
So thank you very much for this very interesting and challenging presentation. I think we open up to a more comprehensive view, not only related to digital platform work, but in a way to the incentive or a positive view of self-employment against employment by the Polish legislator and the Polish government. I would like now to open the floor to questions, remarks. We have one question here, Ralf Rogowski, and then Meike Oberzeil, and then we'll see.
Just a question for, can you hear me?
Yeah, a bit louder maybe.
Okay, just a question for the last paper, just a few more information, and actually two questions. First, can you say a bit more about your own proposals, what reform of the unemployment benefit system should be? Would you propose to go back to a system where the initial unemployment benefit is linked to the salary? Is this something along your lines? And second, what is after the 6 months of unemployment benefit expires? There must be a social assistance scheme. Is the level of social assistance similar to the unemployment benefit, or is this lower or higher?
Okay, let's take the second question from Meike. Yes.
Yes, thank you. Thank you to all the three speakers for the very interesting presentations. My name is Meike Houwerzel, Tilburg University. I don't know if it's if everyone can hear this. Anyways, yes. I was intrigued by this labor contract neutral social security. We also have that debate in the Netherlands. There I wanted to ask the question, so to Marius and Claire, more specifically, how you see that. So if we continue along that lines, what possible impact does that have on the higher category, so to say, of employee protection? Might it lead to, okay, a lifting of the social security position of the ones who are now outside almost, but to the detriment of the ones who are at a higher level, because it might be more interesting perhaps for traditional employers to try to reclassify these workers to in the middle category, so to say. I'm not sure if what I am saying here is resonating to your approach, but this is something we hear often as a response of be careful of what that would mean. So the advocating of well, a kind of broader approach would mean that the ones who are now well protected might also eventually go to that lower level from that perspective at least. And now a last question, if I may, is to Barbara and Sławomir, if I correctly pronounce. Yeah, I was wondering, it's a shocking story actually, I would say. Also in the Netherlands, we have this fiscal stimulus of self-employed, but at least at a low, at a less worrying level if I compare it to your system, but it's still very worrying. And it's very difficult to get across it because there are so many vested interests, and that's probably also in the case in your country. But I was wondering, because if I recall correctly, your classification of the employee is based more on formal perspective than on primacy of the facts. I'm not sure whether this is the case. So that's my question, and also whether that would be helpful to go in that direction, for instance, with strategic litigation of the trade union, and also referring to the employee definition, of course, which is more or less in shape or developing at European level. Thank you.
So, any other question? Yes, in the back.
Well, I'd like to ask Claire a few more words about the role and involvement of social partners and collective bargaining in France in the improvement of the protection measures and well-being policies for the platform workers, and in a more general way for digital workers during the COVID-19 pandemic. Thank you in advance.
Any further questions? No, so I think, Barbara, you are already here, so you can take the floor there, yes. Be careful not to fall from the
Okay, I will try not to kill
stage.
myself. Okay, so there was a question about the reform in the unemployment benefit system. Of course, I can only speak not like what's my personal view, because that's maybe not that's interesting. I can tell you that trade union is a movement, this organization which are in Polish Social Dialogue Council, the one which are representative on the national level. They always speaking about the need to change, to link the amount of the benefit with the former wage. But of course, it needs to increase the contribution. And it's not a hot topic. It's not really discussed. It's more like on a rhetoric of the trade union that we repeated to the government, this government, next government, previous one. But what is a really hot topic is how to spend the money in the labor fund and to give more influence of the social partners, employer organization, trade union, to use this money on the active measure on the labor market, like a training or some subsidizing special contracts when the work is subsidized by the public money. And as Sławomir said, government is very reluctant to it because they can use this money to whatever. For instance, there is one of the big projects of this government which is connected with some extra saving for the retirement. It's not a social security, but some kind of the voluntary system. But you get some incentive from the public money, and this incentive are financed by the labor fund. So you can say this is not really connected with the labor market policy. So it's like, okay, like this. What happened after when there is a termination of the unemployment benefit? Well, it's over. We don't have any kind of the scheme which is simply addressed to these people. Of course, there are some support which is mean tested, which is depending on the income in the family, but then you come absolutely to a different sphere in the, let's say, social security. It's simply nothing. Then you ask me about the division between, let's say, employee and self-employed. Do we have a third category? No, really, we do not have a third category like workers or trabajadores subordinados in Spain, but we have very strange regulation which is giving the right to minimum wage to the people on the so-called civil contracts and to self-employed person. And just one sentence, I will be short, but I think it's quite nice. Like when the government introduced it like 6 years ago, I get a lot of calls from the researchers from Western Europe, ask about it, minimum wage for the people who are not a classic employee. And the people were saying, oh, it's so progressive, this is because of the platform workers, oh, that's interesting, and so on. And I was explaining, no, this is not about platform workers, this is not anything like this. This is in reality, for cleaners and for people who work in security. And there was a big silence on the other side of this, I don't know, phone call or whatever. And a simple question, what a strange system do you have that cleaner who is making very subordinated work, or people who work in security, subordination is also very visible, like a classic subordination, nothing fancy. It's not from the beginning person who has an employment contract, paid holiday, regulation about the working time, and so on. And this is mostly about the implementation. It's not that we have a different system. We have absolutely system like everywhere. The subordination and the visible features of the relation between the employer and an employee are the most important. We have this in the labor code. The problem is that, first of all, implementation in the sense that if you are on the civil contract or you are a bogus self-employment person and you need to go to the court. And this is not about the vision of the court, but how long this procedure takes. And this is very... this is really the problem, how the labor courts work, and what is the access to get this right, which you can have on the paper without any problem. So what the government did with this minimum wage for bogus self-employed or solo self-employed and people on the civil contract was somehow to try to make this from the different angles. This work will be a little more expensive, so we are asking the business to conduct the proper employment contract.
Thank you. Claire, if you want to answer the questions. We have to clean, or yes, maybe you can use it so we have no...
Thank you. Yeah.
Okay.
Thank you very much for both questions. It's a great opportunity, actually, because even though I spent too much time, and I'm sorry, I didn't get to say these two things, and I'm really happy I get to talk about it, so thank you. So for Meta, actually, I don't claim, even though I mentioned the principle of neutrality, I don't claim that there should be complete equality between employees and independent workers. And it's not because we're asking for independent workers to be better treated that there cannot be differences. And actually, I go back to the definition of plateau, of equality. You know, like you treat similar situations in similar ways, and different situations in different ways. And that actually, we already see that, because especially when we take a broader look and look at public and private insurances, we see that, in fact, private insurances can already be proposed to certain categories of workers. And so I don't think that is incoherent. I think it actually works. But yeah, as I said, there should be a basic standard which should be good for all, and this, I think, should be implemented by the state, because this is the only actor which can ensure that everybody gets access to it. When it comes to the second question, I didn't see who asked it, but thank you very much. Yes, it's a great opportunity for me to say it, because I didn't get the time. You might know that we had representatives elections last week in France, and that it was a complete failure. Complete failure. I'm saying that it was like, less than 1% of participation of the platform workers in order to elect representatives who should have been able to negotiate their situation with platforms. And so that gives you a sense of where we are. And during COVID, there were demonstrations. There was a little bit of, demonstration is a big word. There were some movement, and there was, some reactions from the media, from associations, and from trade unions a little bit. But still, we're so far from actual movement. And so that's it. Thank you.
Thank you. Marius, would you like to come here, or maybe for the microphone? Andrea, clean the microphone, or? Yes, he's coming for the microphone. Andrea, thank you. Yeah, just not too close to have it, to avoid. Yeah. Okay.
Right, thank you. Yeah, on the question on the Netherlands experience and so, I don't have the full picture of what is currently being discussed in the Netherlands, but in broad terms, I would actually agree with Claire's response. We shouldn't make the mistake we talk the language of universal coverage, so to say. That does not and should not necessarily translate into universal level of benefit. I think that's the first issue. Second issue is the whole way in which social security is constructed and should be constructed is that subject to, of course, a minimum level of protection, to which Claire also alluded. There is so much need, and not just scope for, but need for a really well-defined and well-developed calibration of the contributory and non-contributory context, bearing in mind probably also some of the private interventions. And there's no need for people on the higher end of the income spectrum to suffer a deficit. Not at all. Not if you have a well-designed system. And I think if there's one place where you could have these well-defined systems, then it is indeed in Europe. Got so much experience of that. Although it wasn't asked, the question wasn't addressed to me, but to her on the collective agreements. I just want to say the following in this regard is we have a few examples in Europe in particular of, on the face of it, apparently successful collective agreements through which coverage has been extended to platform workers. The most well-quoted one is probably the agreement between the Danish trade union 3F and the platform operated by the name of HILFR.DK. And I understand in Germany there have also been some examples. But I would like to indicate a word of caution here. The problem is the issue of representativity is a massive problem. Our trade unions very often, traditionally at least, have not represented these workers. It really takes something to convince them, but even if you convince them, the possibility to organize may be limited. It's not impossible. But more worrying to me personally is on the legal side, so many of the systems that I know would not really allow trade unions, as defined, to extend their services to people outside the employment relationship. And that is the major constraint, which first and foremost we need to address. Then we have to work with the trade unions to convince them to extend their services to other categories of workers. So we can see there are legal and practical, factual problems as well. Thank you.
Thank you. Thank you. We can leave it there. Yeah, okay. So, if there is no other questions or remarks, I think I could comment for 2 minutes before we have to start the new, the last session of commemoration of Marco Biagi. It's very difficult, of course, but I think 2 points were made that I found really interesting. The point of attractiveness of being an employee or a self-employed, so the fact that maybe there is also a question, which is not a stupid question, if it's attractive to be in one group or another group, or in as such the same grouping approach has to be reconsidered in the way, in the perspective of achieving that neutrality corrected by a minimum standard approach. So it's, I agree with Claire, the principle of neutrality, also what Marius supported. It's not that everything is the same or must be treated in the same way, but the fact that we should try to have a minimum standard of coverage, social security coverage, social protection, whatever the kind of relationship. But then, of course, we had the problem of the link between any sort of social protections, any benefits, and a certain condition. So in a way, it's like we are asking for a kind of individual test. So maybe we are going towards an individualization of requirements tested by the public authorities and linked in a way also to the nature of needs. Maybe need is a word that didn't come so often in your discourse, but there is a problem of need, of course. What are the needs of these people, whatever their qualification or classification? And the second point, I think it's about platform offering protection. Yeah, of course, in a state of emergency. So maybe in the moment in which they needed the platform workers, so for instance the delivery services, so they want to keep them in the platform. And then maybe we have to also reevaluate the role of private initiative in the sense of employers or entrepreneurs' initiatives towards their collaborators, and also the fact that in some cases, I think not so few cases, it's not the incentive that makes people self-employed, but there is also a choice to be solo entrepreneurs, solopreneurs, because of the advantages the tax system provides, but also because probably there is a kind of balance stroke between the needs and the future needs and the actual freedom they enjoy being solopreneurs or not to be qualified as employees. So I don't think we have to push people or legislators should push people to be employees or self-employed. It's for the legal system is a matter to provide, of course, affordable and available for social protection. But then I think it's up to the individual and also to the entrepreneurs to choose which is the most effective and suitable model to be used.